Ask yourself why this was, and I submit that it is a very deliberate attempt by the legislature. It is so deliberate, it is intentional. Other lawyers call it for avoidance of doubt. And so you have to show evidence of attempt for the jurisdiction to apply. And then it goes and says, unless, that's subordinate conjunction, right? In other words, there is a dependent clause which is qualified by an independent clause. That is, it must be something. It creates a conditional relationship so that you cannot have jurisdiction at all. In fact, in the change, in the amended, during the amendment, I think the legislator made it more conservative that without adducing evidence of an attempt, there would be no jurisdiction. Before, there would be doctrine of exhaustion. But that amendment took away the doctrine of exhaustion and substituted it with the evidence on attempt, so that it is a single absolute imperative. That is my submission. It is absolute imperative. Absolute imperative. And then it talks about adduced evidence. That adduced evidence must be equivalent to the Evidence Act. It must be evidence that must be proportional to the Evidence Act. And so when one looks at it, it is clear that where there is admission as it is right now in paragraph 15 of the complainant's affidavit, that there is no scintilla of evidence, one would find that there is no jurisdiction. So that the test in the Chebere case in paragraph 45 will not apply if there is no evidence. Now, I listened to my senior counsel on the question of the finality of this thing. That is very misconceived, with a lot of respect, in two ways. Number one, if you consider the constitution of this party, Article 47, I think. Article 47 sets out National Delegates Convention, and in particular 4E and F. It says that the National Convention shall have the following specific powers. E and F says to receive and discuss reports of National Governing Council and NEC. And F, to elect among the eligible party members national officials, blah, 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 blah. It means that when an action is taken out of 74, this process is continuous until there is NDC. It is a process. It is not an event. Until there is an NDC that has the power to elect. And that is why even the secretary, the Deputy Secretary General is on an acting capacity. And so that therefore allows, it would have allowed the complainant to have the party for IDM, because there is space, there is time. And that is why there is Suomoto. Suomoto cannot exist on its own. If it were to exist, it would be unconstitutional. In other words, Suomoto exists because of an interlocutory approach. Just the way the tribunal gave an interlocutory order, that does not culminate into the final order. You may decide at the end of the day to reverse your decision, right? So when you see this word Suomoto in 74, it means it is interlocutory. And so, with a lot of respect, my senior, as well as the former SG, has grossly misconceived the process. I don't have some minutes, but I think I just want to say, the last thing I want to say is that in function in a political party. The office of the chair and the office of the secretary general and the treasurer. These three offices are the, I would call it, alter ego of the party. Today we are talking about an individual, but is anybody thinking about the millions, the thousands and thousands of members of this party who cannot exercise their political rights under Article 37? Is it 37? 37, yes. 38. They cannot exercise their political rights under Article 38 just because three people are fighting. So it is, and that goes to the question of public interest that my learned friend discussed. As soon as that is detected, a responsive political party must look at the thousands of its membership and put an end to infractions which would deny them to enjoy their political parties. Now, quickly, the issue of dispute brought by my learned friend is interesting, very interesting. You know, the ostrich equivocation, and I am very delighted that was brought. But the issue is this: what is a dispute? And when does a dispute arise? A dispute is only mentioned in section 41. In fact, the legislature assumed that a dispute is an English word, which would naturally, it's not a special word. In its natural existence, a dispute arises when somebody is aggrieved or somebody controverts issues that are against him. Until that, there is no dispute. There couldn't be a dispute by NEC. NEC cannot have a dispute by itself. It's not logical. But when the subjects of NEC decision are aggrieved or complaints on a certain set of facts, then that is a dispute. That is when and only when a dispute is determined. And then it says that then it gives the jurisdiction under 41 determination of disputes and how disputes are done. So the manner in which my senior went, I think it will be the first time I've had that submission. But that being the case, a dispute cannot be by the persons who are making the administrative action of the party or the organ that is making it. It cannot be. And so I want to stop there, but I urge you that this is not an academic case. It is never an academic case. This is about people, about political rights, about people who are in the countryside who do not understand the meaning of scintillar evidence. These are people who just want to enjoy their political rights. So when a person puts himself beyond the reach of others and he occupies a position that therefore disentitles others, this tribunal has jurisdiction, and I think that is why the legislature created this tribunal, to be able to balance the rights between an individual and the thousands of Kenyans who would wish to exercise their rights. I thank you.
Okay, thank you, Mr. Pajong. Senior Counsel Okero on agenda.
Yes.
Sorry, Mr. Okero. Mr. Okoko. Sorry. I almost forgot Mr. Wakoko.
Thank you,
Mr.
Honorable
Wakoko.
Chairperson and members. Thank you so much.
Yes.
Honorable members of the tribunal, we responded to the application and the appeal by filing our response in the style of a replying affidavit. It is sworn on 18th February 2026. Chairperson, it is our position that we have been invited to court prematurely in the sense that under Section 40 of the Political Parties Act, the Register of Political Parties has not made any decision that could make a party member or a political party for that matter drag the registrar to court. So, Honorable Chairperson, as the tribunal retires, I invite the tribunal to look at Section 40, and further, I invite the tribunal to look at Section 20 of the Political Parties Act in terms of the change of party particulars, which it is our contention that we are not in receipt of that particular change, and as such, no decision has been made. I rest at that, Honorable Chairperson.
Okay, thank you, Mr. Wakoko. I apologize. I almost forgot you because you said you have no dog in this fight. That's why I was almost forgetting you. We now can go to the rejoinder by senior counsel.
Thank you. Thank you very much. I'm just organizing my notes here. Yes. Honorable Chair and members, Mr. McCurry began, first of all, by unfortunately completely misconstruing the submissions I made in relation to who the aggrieved party was. My submissions are not questioning who the aggrieved party is in this case. Submissions were questioning who the aggrieved party was in relation